Welcome back to Property Insight. My name's Neil Harding.
And my name's Mark Ashworth. And on today's video, we are going to be talking to you about the 5 most important changes of the new Renters' Rights Act, which came into power, of course, in 2025.
Okay, so first up, number 1 of the 5 things that you need to be aware of. And the main thing actually is that Assured Shorthold Tenancy agreements will no longer exist from the 31st of May. ASTs, they were typically called in the past, they're going to become Assured Periodic Tenancies, or APTs, as people will probably abbreviate them to. And what that means is that any AST agreement you currently have in place for a tenancy, that will effectively automatically become periodic. You don't have to start issuing new tenancy agreements, so it's important to remember that. You don't have to start going out there getting tenants to sign new APT contracts. Existing tenancy contracts in place will continue to be in place, but they will immediately become periodic. That means an end to fixed terms of all AST tenancies. So gone are the days where you could advertise a tenancy and say it's a 12-month or it's a 6-month or it's an 18-month fixed term period. And then you might have been letting those go periodic after that. So there might be a 1-month notice period after that. That's going to become completely irrelevant. Okay.
So the wording of the actual contract that you've got with your tenant remains exactly the same, apart from the way that it's set up in terms of its fixed term. So typically most landlords would actually create a 6-month tenancy agreement. Some may provide a 12-month tenancy agreement. Usually, typically with residential property, it's rare for it to be any longer than that. So it's just that part that will actually be changed in the contract.
Yeah. So second thing is, also by the 31st of May, you will need to issue to your tenant an information sheet that the government will provide you with on their website, on the .gov website. It's not available yet, but it will be by the 31st of March. So that basically will outline the key things that your tenant needs to be aware of as this transition happens. So you've got a window there between, well, 31st of March, let's say if it was published on that date, through to the 31st of May, when you need to make sure your tenant gets this, and I think there are penalties if you don't do it, so make sure you do it.
So up until this point, we've always had to serve the tenant with a how to rent guide, which has been changed and had gone through a number of iterations over the last few years. That was introduced probably, I don't know, 7 or 8 years ago, I think now. So this guide is similar to that. It's just basically outlining the rights for the tenant so that they understand what the changes are as well as you do. So it's probably worth actually having a good read through it before you give it to your tenant as well, so that you can be fully mindful of what's going on. Yeah. So number 3 is the end of Section 21, or the so-called no-fault evictions. So landlords must have a valid reason to evict, which essentially is not strictly true, is it, Neil?
No, I've always had a bit of a bee in my bonnet about the phrase end to no-fault evictions as part of this act, because although Section 21 is what people typically mean when they refer to end of no fault evictions, the act also brings in new grounds, which we'll come on to later, as to how under these new grounds under Section 8 that are also no fault of the tenant, that eviction can happen. So it's still going to be possible to evict a tenant. Some of them have reasons, some of them have fault, some of them don't have fault. Anyway, the point is Section 21 is being abolished.
So what it means is that if you've decided for whatever reason that you don't want your tenant to live in the property anymore, you have to go through either a process that allows you to evict the tenant because they have or they are at fault, which typically would be antisocial behaviour, always been very difficult to evict tenants on antisocial behaviour grounds, I might add, or non-payment of rent. We'll cover the non-payment of rent thing in the other point because that's a very important point that we need to address. But yeah, the Section 21 where you just feel like you might just like to be renting it to somebody else, you can no longer do.
So point 4 brings us on to section 8. So the grounds for section 8 are going to change. As Mark was talking about, there's an existing grounds for possession at the moment which will remain in place, which is for unpaid rent, so rent arrears. Currently, if a tenant goes 2 months into rent arrears, if it's a monthly payment frequency under the contract, then you can serve a section 8 notice after 2 months of rent arrears, give 2 weeks of notice for the tenant to vacate the property, and that period of time must lapse before you can then consider, do you want to go to court to start the process, for example, to seek a possession order from a court. Now, those timelines are changing. So instead of 2 months of rent arrears, that becomes 3 months of rent arrears before you can serve a section 8 for that grounds for possession. And the 2 weeks notice for a tenant to vacate becomes 4 weeks. So in effect, a total of very close to 4 months, really, before you go from, the tenant's not paid rent, to having served the notice to actually then consider, do I want to actually now get a possession order from the court?
Yeah, make that.
So it's quite a long time. It's quite a long time. Yeah. So the one key thing that we think, actually, if you're someone that was thinking about getting rent guarantee insurance previously and you weren't quite sure and maybe decided not to, you might want to now think, actually, I think it's worth it now. Because that's quite a big, I mean, 4 months is a long time for a tenant to go without paying rent, if they go the full 4 months. And that's a lot of money for both you and them. I don't think I've ever seen a tenant go 4 months of arrears and then actually pay it.
And to be perfectly fair with you, it would be well worth considering increasing your rent very slightly to cover the cost of that rent guarantee insurance. Yeah. It might be worth considering.
And then section 8, 2 new grounds for possession under section 8 umbrella have been introduced, which is what we were alluding to just a moment ago, which are kind of no fault grounds for eviction. One being that you decide as the landlord that you want to sell the property, or you decide that either yourself or a close member of family want to move back into the property that you used to live in. So under both of those scenarios, you can serve section 8 under these new grounds to get possession of the property.
Again, no fault.
No fault. Yeah, no fault. Okay, and then the last point is around number 5, rent increase rules.
So this is limiting on how often and by how much you can raise the rent. It's kind of been seen that usually you would only increase it by however much once a year. So once the tenant's been in for the year, you can then increase, and that you would typically issue a formal notice. If it goes to arbitration, then a judge can decrease the rent, but you can no longer increase it. I mean, I've never had a rent review clause in any of my tenancy agreements, but if there are those in there, then that's the other thing in that AST agreement that would cease to be applicable. So yeah, I mean, I don't think there's an awful lot to change here, but I'm guessing that really the big thing is to make sure that you do it by formal notice, and that it could go to a tribunal if the tenant disagrees. I've always found rent increases with my tenants to be mutually accepted, typically by phone call, text or letter, or a combination of all three. So I think it's just being open, transparent, communicative, but more importantly, making sure that the rent increases are fair and that they are in line with inflation and not too crazy. I don't think you can increase it to encourage people to leave, should we say. No. That would be seen as wrong. So there you have it, guys. 5 reasons why, or 5 things that you need to know about the Renters' Rights Act. Hope that you found that useful and insightful, and we'll see you on the next video.